copies, so anyone that didn't get all 3 handouts, there should be 2 that Kevin Lemieux prepared, and then the eval, so anyone who didn't get those, just let me know and we can pass them around so that you all have them. Today we have Kevin Lemieux here. Anyone who came to the training in February, you probably recognize him. He was one of our presenters on our other trial skills training. So he is back to present today on child witnesses and character evidence. He has a background in dependency, he has a background in family law, so he actually knows what we do and can speak to that. So,
thank you. All right. I should have worn shorts and flip-flops. If you're offended I took my jacket off, I apologize, but it's hotter than a monkey's uncle in here. And I was telling someone else, one of the first folks that got here this afternoon, I'm not going to keep you late, so don't worry about that. But if you were here last time, we had a bunch of fun, myself and a guy named Jim McMahon, and we had you guys for a whole day doing expert witnesses and impeachment and refreshing. Was there anybody, I've been told we lost a lot of people at this firm, but hopefully some of you guys remember that. Today's training is a little bit more technical, so I'm going to try to not bore you to death and turn it into an evidence lecture, but there is a little bit of evidence in these 2 topics, the child witness and character evidence. They're both sort of misunderstood in dependency law. So like Rachel said, I do have a background in dependency. I represented parents for, I don't know how long, like 12, 13, 14 years I've been doing it. I used to be the supervising attorney in San Diego for the primary parent office, which is just the same thing you guys do. Before that I was a public defender, now I'm a solo practitioner. So I spent a lot of time teaching trial skills for NIDA, the National Institute for Trial Advocacy, and for the Juvenile Law Society. So this is something I like to do. Please, while I'm going, if you guys have questions, don't be shy. You can raise your hand, you can throw something at me, whatever. If you need a break, if the oxygen is not in the room anymore, let me know. I'm cool with that too. So before we get started though, I just want to get a feel for your experience level. How many people in the room have been practicing for 1 year or less? Please, show of hands. All right, so a few of you guys, not a ton. How about 3 years or less? Okay, 5 years? Is there any 10-year folks in the room? Nice, I know who to call on. All right. One of the things I find, so my job in San Diego, we're not as big as you guys. We had 2 offices for parents' councils, kind of 3. But my job was supervising the attorneys that were in the courtroom. One of the things that I found in doing that was that for some reason, particularly new lawyers get nervous about putting kids on the stand. And in our line of work, it's something that you just have to do every now and then. It's not super common, but there are certainly cases where the kid is the best or the worst witness for us, right? So I just want you to be more comfortable putting kids on the stand and being familiar with the law. One of the things that people get mixed up a lot with regard to child witnesses is their ability to testify. So we're going to go through that quite a bit. Also, I'm kind of informal. I'm going to call him the kid, or do I need to call him the minor to you guys? Is it okay?
The accuser?
Yeah. I don't know if I call him the little brat kid, the liar, whatever. But I may not just refer to them as the minor, so I'm sorry. So let's jump into it. We're going to do the child witness first. Okay? And you'll notice, obviously, I gave you guys some sheets you can follow along. Your written materials have more information than my PowerPoint. My PowerPoint was drafted from this. So you'll notice you did not get a copy of my PowerPoint. There's nothing in the PowerPoint that's not in here. Okay, so you're not missing anything. There's more in here. All right? So examining the child witness in many cases can provide the fact finder with the most compelling evidence in a child welfare case. Duh. Right? Forgive me, I have trained minors counsels too. Whether you represent the minor or the parent or the county, you need to be willing to cross-examine or direct the brat kid. Okay? And in everything I try to teach, I try to focus on teaching you how to do this in a persuasive way. So any lawyer can get up and ask questions of any witness. And probably someone off the street who's not a lawyer can get up and ask questions and get facts out of a person. It's not that hard, right? What makes it artful and what makes lawyers good at it is doing it in a persuasive way, okay? So that's something we're going to focus on, trying to be persuasive when you're examining a child. And I recognize that 90% of the time in this room, it's going to be on the cross for a kid. All right, but every now and then you may have a kid up on direct. Okay, so we're going to go over both, but I recognize most of the time when you guys have the minor on the stand, it's going to be during cross-examination. So the first question is, can I examine this witness? All right? In other words, is the child competent to testify? Competency is something that people focus on, I think, a little bit too much. So I'm going to dispel your concerns about competency. All right? In most cases in California, the answer is yes. The child is almost always competent to testify, even young kids. Okay? The evidence code we look to here is 701, subsection A. It requires only that a witness be capable of expressing himself. It doesn't say speaking. Capable of expressing himself, herself. And capable of understanding the duty of a witness to tell the truth. So, if you're on direct with a minor, this is pretty easy to demonstrate. Okay, and you've got it in the written material, sort of an example. But when you combine the ability to express oneself and the understanding of the duty to tell the truth, that's what we call competence. So that's step one. Is the kid competent? Is a 2-year-old competent? Maybe. If you can ask them the right questions. All right, and what you guys need to understand, competence refers to admissibility of evidence. Okay, not weight. So, let's say I put a 2-year-old up, and I can demonstrate that he can express himself, he can talk. We're not going to talk to him about anything complicated, but 2-year-olds can talk. And are they capable of understanding the duty to tell the truth? Maybe. I mean, you're gonna try, right? That governs admissibility. Admissibility means, are we going to allow this witness to testify or not? Now, even if I have a 2- or 3-year-old and I can demonstrate to the court that she can talk and she knows to tell the truth, we're going to have a weight argument, right? There's still the, come on, judge, this is a 3-year-old. And that goes to weight, but that's not competence. Competence is admissibility. Okay, so the kid gets to talk. The kid gets to tell their story. If they're competent, you then just get to argue to the judge that it's a 3-year-old, let's take that testimony and throw it in the trash. But they get to talk. Okay? 701B says, in any proceeding held outside the presence of a jury, the court may reserve challenges to the competency of a witness until the conclusion of the direct. So we call this the wait-and-see approach. Obviously, we don't have juries in dependency court in California. Some states do, like 18 states do. But we don't. So what this means is, if you have a competence objection, okay, your objection is that this child should not even be allowed to talk, you're going to get put on hold, and the judge is going to wait and see. Normally, if you're in a jury trial and you have a competence objection, we fight about this outside the presence of the jury. You can take the kid on voir dire, etc. But here, the law presumes that there's no prejudice, in the judge hearing this, because judges have magical powers to unhear things and not consider things. So the judge is going to say, go ahead, do your direct exam, and we'll see throughout the course of the direct exam if the child is able to express him or herself and understands the duty to tell the truth. So you're going to get shut down early is what it means. If you're trying to keep this kid's testimony out, the whole direct is going to happen before the court rules on that objection most of the time. The most common issue is a child's ability to tell the truth and understand that. It's usually addressed in direct. Below is an example. So you'll know in my example some of these questions. This example is on direct, but some of the questions are leading. And that's okay for two reasons. One, you can use leading questions in certain circumstances with minors. We'll get into that later. But you're also laying a foundation. So if they're responding to your objection on competence, they're allowed to lead the kid, okay? Because it's foundation. So, yeah, I have a slide. So, little Jimmy, do you know the difference between a truth and a lie? Yes. What's the difference? A truth is true and a lie is not true. Do you understand you must tell the truth when you're in court? Yes. What will happen if you do not tell the truth today? I'll get in trouble. That's right. Question is, that's right. Lying in court is called perjury, and it's against the law. You know what happens if you break the law? The police will take me to jail. So obviously, little Jimmy doesn't know that perjury is never prosecuted generally. Especially not against children, victims, in dependency cases. That doesn't matter, right? He's demonstrated an understanding that I'm supposed to tell the truth, and there's going to be some kind of consequence if I don't. So that's enough. I mean, boom, your competence is done. This part demonstrates their ability to understand the oath. It also shows he knows the difference between truth and a lie. You're probably going to see these same kind of questions. Has anybody read a forensic interview? Like, do you get transcripts of your forensic interviews up here? So you're going to see these same questions because it's all the same theories from forensic interviews to testimony, right? You want to demonstrate that the kid knows the difference between truth and a lie. So you may see a lot of these same questions when you read forensic interviews. And this should give you a little bit of insight if you read a forensic interview and it doesn't have this stuff, right? That's where you can attack and cross the examiner or the social worker. So I'm going to give you some links at the end of this because, you know, the folks that the folks out there, does anybody, he's an LA guy, Dr. Myers, Dr. Evie Myers, have you guys come across him? He's a famous researcher on child trauma, and he's done a lot of research on dependency. Anyways, he publishes studies, I forgot what school it is, he's in LA though. But he gives a lot of the ammunition to the child advocates of the world. But it would behoove you to learn some of this stuff because then you would know where to attack when the proper formula is not followed, which I know you guys in this room more than anyone understand that most department social workers would never make a mistake or follow, fail to follow the exact procedure, but you need to know where to attack, right? All right. So I said here, it's not important that he knows what the consequence for lying is, just the fact that he knows that there is a consequence. The next part of the exam demonstrates that he's capable of telling the truth. So this goes beyond asking him, do you know the difference between a truth and a lie? Now I'm going to demonstrate that the kid can tell the truth. These questions should be simple and should be things that the child knows. It's foundation. So it doesn't have to necessarily be about the facts of the case. And again, if you're going to be crossing this kid, these are things that you can object to as far as competence goes if the attorney on direct does not do these things, okay? So the rest of it, did I put it up here? Yeah. Jimmy, how old are you? I'm 6. What are your parents' names? Mark and Stacy. Where do you go to school? Lincoln Elementary. What building are you in right now? I'm in court. How did you get here today? I came with Miss Jane. All right, super simple, has nothing to do with the case, but you've demonstrated to the court that the kid's not loopy and the kid can tell the truth. If you're on direct, okay? By a show of hands, who has had a child on the stand for cross-examination? Raise your hand. Okay, maybe a third or a quarter. How about on direct? Oh, it's the same hands. What's up? Okay. Is it? Oh, wait a minute. Raise your hand if you did that as minors counsel. Okay, you don't count. Or the old stuff doesn't count. You count now. So yeah, you guys got to get the little minor on the stand. Now, I fully acknowledge that a lot of times the minor is the absolute worst evidence that is going to come in against the parent. But if they're putting the kid up, if someone's putting the kid up, whether it's county counsel or minors counsel, you should be cross-examining the kid, right? Don't sit down with a no questions unless the kid's testimony was a nightmare for them. But assuming it's not, you should be crossing the child. Don't be intimidated that it's a child. You don't have to beat the crap out of the little victim in order to get good evidence out of them. We're going to go over that too. All right, so both prongs of 701 are satisfied by that little direct exam. The child can express himself, he can differentiate between truth and lie, and then he demonstrated it, right? And we did that through asking him simple questions. Question for someone in the back row. You looked up right at the wrong time. Do you do this for every child witness on direct?
No.
Why not?
Because you shouldn't always call a kid to the stand.
Okay, but let's say you are in this case. Should you go through, and by this I mean going through the competence foundation. Do you do that with every minor witness?
No.
Why not?
Because some of them, you're not going to question their credibility, their competence.
Right. So what if the kid's 14?
Well, if he's 14, I'm pretty sure he can competently testify.
Now what if he's 14 but has schizophrenia?
Then there might be some issues with competence.
There might be.
But
Or
not necessarily.
he's 14 and has PTSD because your client beat the shit out of him for so long. You can spin that. Allegedly. Oh yeah, and throughout you guys may hear me say the agency. You all call it the department up here. Where I'm from, we call it the agency. It sounds a little more cloak and dagger. I like that better. Department sounds kind of bureaucratic and less evil. So they're the agency to me. So yeah, you're right. If competence isn't really an issue, you can skip this. All right, so this is the fun part where you all get to stand up. Just pick a partner that's next to you, and I would like you. You're going to switch, so don't feel like, oh, I don't want to be the witness. One of you is going to be little Jimmy. One of you is going to be minors counsel on direct. 2 goals to accomplish, 5 minutes. Right? So he's nice. He's nice. 2 goals. your hand if your partner is not competent to testify. I saw more hands than go up. So it's pretty simple stuff, right? If you're putting a kid on direct, go through this. If the other side skips it and there's an issue with regard to competence, object. All right? You're blocking my fan. Holy cow. All right, it's hot. Okay. So, any questions on this? It's pretty simple, yeah.
When you said objections wait until the end?
Well, the code section allows, you should object in the beginning. The code section allows the judge to rule on it at the end of direct. You can also, if you don't think competence is an issue and you don't object, that's fine. And then when county counsel or minors counsel or whoever is through their direct, you can then make your objection, right? And you can cite the code section. Like the judge can't tell you, oh, you've already waived that objection. Because no, we determine this at the end of direct when there's not a jury. And, you know, I expect most judges will let them redirect, but they shouldn't, like, make your record, you know. Who's got a judge that gets pissed off when someone states, we're going to call the minor in this case? Yeah, I'm surprised it's not more. That's one of the things that I find that makes people reluctant to put kids on the stand is you're afraid you're going to piss off your judge. And let's just get it out in the open right now. Screw your judge. All right? This isn't about your judge. It's about your client. So let your judge be pissed off. You know, it's good for him.
It could be good for her.
Good for her too. Forgive me. Second. All right.
Good job.
I'm just kidding. So remember 701B. You have the whole direct to demonstrate the competence. So you don't have to hit this first. If you have the kid on direct, you can do it. You know, throughout anywhere. You can sprinkle this in anywhere if you want. But there is a thing called rapport building. So if you do happen to put a child on the stand in direct, even in cross as well, you know, it may do you some good to build rapport with the child first. You do that by not jumping into, you know, the night daddy diddled you. You might want to start with, you know, so I hear you play soccer, right? You don't want the kid to be afraid of you. All right. So what if the kid does okay, but not great at demonstrating competence? California law is super liberal on this issue. That's why I said in the beginning, in California, the answer to the question is the child competent? The answer is usually yes. This case is crazy. Amy M. Right? This kid was 11, and she was found competent to testify despite the fact that she was having active hallucinations during cross-examination. Okay? Tell me about the little man that's up there on the witness stand with you, Amy. And she did. And they said, well, we could tell the parts where she was crazy and the parts where she wasn't crazy. And the court said she's competent.
Was it overturned on appeal?
No, this is the appeal. The appellate court said, no, she's good. Okay, so again, but this demonstrates the difference, right? This is important for evidence. The difference between admissibility and the difference between weight. So all the court's saying here is admissibility. That means she's allowed to talk. That's all admissibility means. She's allowed to talk. It doesn't mean that what she says means anything. So if you're the parents' counsel on this, assuming this kid is bad for our case, you're going to go crazy in closing about weight. Okay? Okay, Your Honor, you let it in. I get it. You know, we'll give the minor a chance to say what she's got to say, but my goodness, you can't give any weight to that. She's talking to little men that aren't there while I was talking to her. Right? So wait. But there's a difference. You have to understand the difference, right? It's like the difference between people screw up this with foundation a lot as well. Foundation is, do we even get to look at this document or this gun or this expert's opinion, right? Not, is it worth anything? And they're two different. When you lose on admissibility, which usually you do, courts err, especially without a jury, right? In our area of practice, you almost always lose on admissibility. The court says, oh, who's heard the nonsense? I'll give it the weight that it's due after yeah, thanks, Judge. You almost always lose on admissibility, but that doesn't mean it's worth anything. You need to hammer it home in closing that there's no weight to this. You can't rely on this. Oh, omnipotent judge. All right. Once you determine that you can examine the child, competence, the next question is, should you? This is the one, this is the question that matters, right? It's an entirely subjective determination based on your theme and theory of your case and your trial strategy. Please have a trial strategy and a theory. Don't be minors counsel and say, I'm going to make up my mind when I hear the evidence. Your job is to craft the evidence, right? No offense. I teach to minors counsels too all over the state, and it drives me crazy that they're lawyers. A lawyer would go into a trial not knowing what their own position is. How can you advocate for anything if you don't even know your position? So please have a position and a strategy, and understand before you start, is this going to be good or bad for my case? You know, here's a super simple example. You represent the DV perp, and he's telling you, little Jimmy's going to tell you that she hit me first. Okay, great. So he's going to prove up jurisdiction on the DV allegation. Why don't we leave little Jimmy off the stand? Okay, because I don't want to put him on to have him testify about the multiple fist fights. It doesn't really matter who hit first, right? So it's subjective. Your first consideration is whether or not the child's desired testimony already exists elsewhere in the record. Now this is especially for minors counsels, county counsels, and for the rare instances where the kid's testimony is helpful to our case, right? B petitions, neglect petitions. If so, California has a dependency hearsay exceptions for statements of the child and others contained in social worker's report, right? So you guys are all familiar with 355C of the Welfare and Institutions Code. It is the social worker report exception, right? The kitchen sink exception. So there are times when if you make a subjective determination that it's just not going to get any better than the way the kid said it to the social worker, like it's really good, don't put the kid up and ruin that, right? Like if it's really good already, leave good enough alone, because it's going to come in, as you know. All right, so let's get into 355 a little bit, because people screw this up. This is with regard to jurisdiction. You all call it adjudication up here, right? Or does adjudication mean juris and dispo to you guys? What's your nomenclature? Someone explained it to me. It means both?
Yeah.
Well, like some courts have jurisdiction where you just, it's a settlement date, and then you'll have a backup trial.
Okay.
Some courts do it all on the same day.
Okay. Well, we're talking about the court taking jurisdiction, so true finding or not true finding, right? California's dependency hearsay exception for statements of the child and others contained in the social worker's report. Note that at the jurisdictional hearing, respondent parties may object to hearsay contained in the report, including the kids. In such a case, the court may not rely solely on those hearsay statements as the basis for jurisdiction unless petitioner then establishes one of the C1 criteria exceptions, which you all can look up yourself. However, even if petitioner fails, in other words, one of those C1 exception criteria does not apply, the statements are nevertheless received into evidence. right? So that just means that the court can't solely rely on it. There needs to be some other little fledgling piece of evidence that the court can point to and screw your client. So it's coming in. Make your objections anyway. Do you guys do written 355 motions?
Yes.
Okay. So do that, but you need to know, even with a good objection, timely made, and it does not fit one of the criteria, it still comes in. You still lose. All right? It just can't be relied on solely for jurisdiction. It gets worse. After juris, in subsequent hearings, the social study is received without limitation on the reliability of hearsay statements. Everything is admitted subject to cross. Okay? So the big fight we have in San Diego is who is to produce that witness for cross-examination. Do you guys have that worked out? Like, let's say they put a statement from the neighbor that says, you know, I see dad beating the crap out of mom all the time. Who needs to produce that witness? Do you have to track down this guy, or do they?
County council.
Prior to juris.
Yeah, we give
Right,
them
so if
notice.
you file a
We expect-
355,
We expect them present for
They,
cross-examination.
right, and if they're not there, then it's excluded.
oh, that's good. Well, at least that's like settled here. In San Diego, County Council argues it's our burden to go track down this homeless drug addict that we can't find. And it's a big fight. Due to the statutory scheme, it's an unusual case where the petitioner calls the minor on direct, as all the child's prior statements should be in the social study. Right? So they really shouldn't be calling a kid all that often, because they get the kitchen sink rule. Right? So maybe it's a red flag if they are planning on putting the child on the stand. Might be an opportunity. All right, and then prior to the social study exception, we had Cindy L. in the 90s. That's the child hearsay exception. I'm only pointing this out so you guys know that it exists. There's another avenue to get child-specific hearsay in a dependency case, but nobody uses this anymore because the kitchen sink exception kind of threw everything in the, everybody in the pool. So, but you need to know there's other avenues that they can get it in. So, considering the minor statements likely already exist in the record, opponents of those statements, that's you guys, may wish to cross-examine the child. This is a delicate process in most instances depending on how young the kid is. The main consideration is in whether or not to cross the minor is what are your goals, right? A lot of kids will recant because we all know that they miss mommy and daddy, even though mommy and daddy are dirt bags. They love them and they miss them. You can bring out inconsistency in their prior statements. Kids screw things up. There's actual studies on this. You can look at the same guy, John Myers. Kids screw up time and timelines more than anything else. That can be very helpful, right? If you want to add to the kid's story, so in other words, your client says they're leaving out all the good stuff, everything positive that I do with my kid, let's say it's a B petition, you want to bring that stuff in, and it can add emotion. Usually that does not work in our favor, but you never know. Special rules for the child witness. Evidence Code 765B protects the child from undue harassment, and it allows the court, this is a quote, to control the mode of interrogation. This is the don't be mean to Jimmy rule. Okay? Do you guys do 350B motions? Kid testifying in chambers, does that happen a lot?
Yeah.
Yes.
Okay. You should know that it's not automatic. Okay, it shouldn't be, is it automatic when they ask for it?
Yeah.
It's not supposed to be. Right? It's only supposed to happen outside the presence of the parents in chambers. If you're on the case, there's a lawyer. But second, proponent can show that it's necessary to ensure truthfulness. The child's intimidated by the formal court process, or the child is afraid to testify in front of his or her parents. It's not automatic. Is everybody going to look at you like the evil parents counsel when you object to a 350 motion? Maybe.
Doesn't matter.
But if the kid's 12,
Right.
sit up there, you know? And especially, I mean, look, this should all be handled before your trial. I understand that dependency court is not exactly motion and limine heavy outside of 355 motions. So you may be fighting about this right before the kid's going to be called. But I think they need to provide evidence. I think the first few questions of the kid need to be on the stand, right? Unless at least this evidence needs to be in the social worker's report that they've talked about it. It's not automatic. More special rules for the brat kid. 767B allows the attorney to ask leading questions. Okay, if the kid's under 10. But you want to use this sparingly, especially if you're on direct. Well, I mean, only if you're on direct. If you're on cross, ask leading questions. But if you're on direct, just because you can ask leading questions doesn't mean you should, right? Is your hand up? Oh, you're stretching. Am I putting you to sleep? Leading questions, there's a question.
How's that different from 776?
Maybe I have a typo. I'd have to open it up.
Okay.
You want to use this sparingly. So what I was about to say is that the whole reason why you want to use direct, open-ended, who, what, where, when, why, how questions on direct exam is because it allows the witness to tell their story. And when the story comes from the witness, it's more persuasive than when it comes from you. Right? So if you have this kid on direct, you want the judge to hear from the kid. Right? You don't want the judge to hear from you. You don't want an early closing argument here where you're spouting it off. The kid's just going, yes, yes. Mommy takes you to school every day? Yes. Mommy makes you breakfast every day? Yes. You know, Mommy hardly ever shoots up in front of you? Yes. You want the kid to talk, right? That's what's going to be more persuasive. So if you're going to put the kid on direct, you're allowed. So if they get stuck, right, or they just, you know, a lot of times when you have a witness on direct, you kind of know they're picking up what I'm putting down, like we're going down this road, we're on the same page. And sometimes they miss it and you're like, God, this person's an idiot. And I got to think of a different way to ask it. With the kid, at least you can go, you know, she does make you breakfast every morning. Like, you can get him back on track. You know, but then you want to, as soon as he's on track, stop using leading questions. Get back to the open-ended stuff. Who, what, where, when, why, how. Those are your friends on direct. Yeah, and same thing with laying foundation. Right? Foundation, typically, it doesn't matter if you use leading questions on foundation because it's not persuasive anyway, it's just foundation. You guys would be happy to know that I'm ahead of schedule. Maybe because it's hot as balls in here. Can the child's story be trusted? Right? Young children are more susceptible to suggestion than adults. That's a proven fact. There's studies you can cite if you want. You can cross the social worker on that kind of stuff. Okay? The Adjudication of Child Sexual Abuse Cases by John Evie Myers. Sexual Abuse of Children. That is the journal. Volume 4, number 2, page 85. Cites that deliberate fabrication is uncommon, but poor interview techniques can distort and even create memories. Okay? Poor interview techniques can create memories. So, by the time this kid shows up in court, there's the initial interview with the investigating social worker. Maybe someone at the school interviewed the kid even before that. There might be a police interview. There could be 3 or 4 interviews before this kid even got to the forensic interview with the person who actually knows what they're doing. Okay, so you need to be on the lookout for this sort of thing. Now this is closing argument kind of stuff, but it's real. Okay? Maybe if you really master poor interview techniques, you can create some memories for little Jimmy. That's unethical, I didn't say that. Okay? But you can ask a social worker about it. Multiple interviews, I think it's super fair to bring up how many times this kid was interviewed, right? And especially in the beginning, we don't have transcripts of those interviews. We just have all the really bad things the kid said written down as quotes. We don't have the questions written down as quotes. We don't have a videotape. So it's important. Am I going to be hurting the kid, the minor, by calling them as a witness? This is the same guy, Myers. Children are strong and resilient, and most of them cope with testifying and move on with their lives. Indeed, with proper preparation and support, some children are empowered by testifying. So this is the whole thing about you know, everybody is afraid. Like, we don't represent the kid, but nobody wants to beat up on a little kid, right? Understand? We don't want to cause trauma, and that's reasonable. But you should know that every cross-examination, every testimony doesn't necessarily cause trauma. We tend to think that it does. We tend to think it's bad to put them up. This particular study just says it could be bad, it could be neither, and sometimes it could even be good. Now, are there techniques how you can do this without causing harm? Yes. We'll get into that in a little bit. The bottom line is be nice. But you shouldn't assume that you're going to be causing some kind of trauma and damage to this kid every time you put him up on the stand, because it's just not true. All right, so you know that you can cross-examine the child or direct the child because the child has demonstrated competence. You know that you should examine the child because it's going to help your case, or they're putting them up anyway. And you're aware of the special rules. Now you can prepare your exam. No matter who you represent in the case, it generally will not help your cause to attack the child witness. Okay, now these words I chose specifically. You may want to attack their prior statements, their prior testimony. You do not want to attack the child witness. Okay, so think about the distinction when you have like a really competent professional social worker who testifies well, and you know when you get his or her reports that, you know, you can talk to your client, you go, I come across this lady a lot, or this guy a lot, and, you know, they know what they're doing. There's certain things you can cross them, but you know they're going to do a really good job, and they're good at their job. And then there's some social workers that you're like, oh, it's on, right?
Yes.
This guy's an idiot. I'm going after this guy, right? And that's the guy you attack, or the gal you attack, right? With a kid, we're just taking that one out of the equation. You can attack the story, you can attack whatever, but it's almost, and I say almost, I'm sure there's exceptions, but there's almost no value in attacking the person when it's a kid. Especially if you're in front of a jury. The jury will hate you. Who plans on doing this until the day they die? 3. 4. The rest of you may be in front of a jury someday. Don't attack the kid in front of a jury. Like that's the day you lost your case, right? And the whole, you get more with honey than vinegar. You're much more likely to elicit the desired testimony by using the opposite approach. Make friends. So typically, people get bored when I tell war stories, but I'll just tell you, I learned this firsthand. I had, I was a young lawyer, which was just like yesterday, and I had a molest case that was both a D petition and a J petition, but the victim was a 17-year-old boy. And my client was stepdad, and, or pardon me, I had mom. Stepdad had retained counsel, a very, very experienced criminal defense attorney in San Diego. And we were doing a case together. We both represented one parent. When it came time for the victim, the 17-year-old boy, to testify, I had gone first on everything because this guy didn't really know dependency. He was kind of following my lead. You know, he's a criminal guy, but his skills were like tight. And when we put the kid up, he said, "Hey, do you mind if I go first?" I said, "No." But I was ready to rip this kid. Like, his story changed like 3 times. He just didn't like his stepdad. You know, I was going to show the judge what a lying sack of shit this kid was. And he was 17, so I was like, I'm ready. Like, I ain't treating him like a 6-year-old. Like, I was like, okay, man, I'll calm down a little. You can go. And he went up and he just smiled. And he's like, "Hey, you know, I'm going to talk. I want to talk to you and ask some questions." He was the nicest freaking guy. And I was thinking to myself, oh, like, he's screwing it up. You know, but again, I was new at this. And he got this kid to talk in circles. And I mean, the kid not only changed his story from the last time he told the story, he changed his story then and there from what he said like a half an hour earlier. And he just, "Oh, okay, tell me some more." Now, and everything was with a smile. He totally made friends with this kid. The kid had no idea that he was screwing up the case, right? And I learned so much from watching this guy cross-examine this kid. And so, obviously, this doesn't have to only apply to children, because this kid was 17, he was a senior in high school, and that's why I figured he's fair game, right? We were not in chambers, the kid was on the stand. But man, I just learned a lot that day watching a real professional make friends with the witness that he was taking apart with a smile, and the witness had no idea. So that's the goal. You know, you're going to get, when you go on the offensive, now there are some people you have to attack, right? There are some bad social workers, there are some bad cops when you do criminal defense, that I have to attack this person, this is outrageous. With kids, just be their friend. When people get attacked, they clam up. They're not going to give you as much information. Right? So even on cross, if you can get that kid to talk in circles, it's a good thing. So this is my advice. Make friends. All right? At least try. And then if the kid's mean to you, like a 17-year-old, you still look like the good guy, right? Especially if you're in front of a jury someday, except for the 4 of you that are going to die doing this. The first step in becoming friends is to build a rapport. This is even on cross. We talked about this before in direct. But you want to mix in questions that are easy, possibly leading. Your goal is to simply start the communication process, right? I think I put one in here about kid playing video games. Hey, I heard, you know, and you can piggyback off if they built a rapport on direct and talked about, you know, oh, you like to play video games, you play soccer. You can say, oh, I heard you say before you like to play soccer. You can talk to them about that for a minute, right? It's also the time to give the kid instructions. You should be giving your adult clients instructions too, or ask them about the instructions that you gave them prior. This should include what to do if they don't understand or don't know the answer. I think I put a question answer in here. Yeah, I said, if I ask you a question that you don't know the answer to, I want you to tell me that you don't know, okay? Kid says, okay. If I ask you a question you don't understand, just tell me that you don't understand the question, and I'll try to ask it in a different way so that you do understand. Okay? And then you say, finally, if I say something that's wrong, I want you to tell me that that's wrong. Okay? And that's the way I talk to a kid. All right? Okay, we're on the same page. Now we'll go forward. Like, I'm not the mean guy. You can talk to me. You can tell me stuff. That kid didn't see me cross-examine the social worker. Oh, I put it up there. All right. I just went through that. I don't need to repeat it. Tips with kids. Leading questions are a tool to control the witness. Okay? This tool is even more effective if your witness is a child. One reason for this is that children may see lawyers and court personnel as authority figures, and thus will not want to argue with you, even though you just told them. If I'm saying something you don't understand, tell me you don't understand. They may still be too shy to speak up or to answer the question in an open-ended way. So if you're on cross, control them with leading questions. You know, the scenario of neglect always pops into my head. You know, mommy does this, mommy does that. You usually go to bed at the same time, or whatever it is. You know, just go through it. You're given the facts on cross. Children are less likely to elaborate on their answers. They may give detail when prompted, but if they're asked a yes or no question, especially in a stressful environment, they're much more likely to just give you a yes or no answer. Whereas you guys have all had the adult witness on the stand who refuses to give you a yes or no answer. They think it's like sport. It's court sport, you know. This is my silly little thing. If you're in my last training, you don't have to be cross on the cross, right? You control the witness with your questions, not your tone, not your attitude. You can sometimes with your body language, but the bulk of it is the questions. You want to craft questions that they can't get around, right? Maintain a calm and friendly tone. Stay friends. You want to focus on their inconsistencies. Okay, so that one where the guy cross-examined the 17-year-old, we actually won that case. We got the petition dismissed. And the kid testified about some horrible shit. But he screwed everything up. Like, you know, the first time was a totally different incident when he was on the stand than what he told the social worker, than what he told the forensic interviewer. Just, if you find an inconsistency, go down that road, right? You want the details, even though they may be bad details, they're different details. So, you want to focus on the inconsistencies. Bottom line, crossing a kid can be dangerous. For some of you, your judge may not like it. It could leave a lasting impression on your judge for the life of the case. So if you do beat up on the kid, the judge may hold that against your client. I've had that happen. But if there are good facts left out or lots of inconsistencies, then you should be crossing the minor. Okay? And just be nice. Then the judge shouldn't hold anything against you. I'm a nice guy. I'm just pointing out that she's talking to little green men right now as we're here in court. Right? So, yeah, we're way ahead of schedule because I knew that you guys, but I'll think of another topic to make sure you guys stay the full amount. I know that's what you want of me. I got 2:30. Break time. Wait, well, hold on. Questions about kid witnesses. I already said break time, so now no one's going to raise their hand. I'm going to ask again when we come back. All right.
How long is
10 minutes.
you want to go?
Let's do quarter of.